Good morning, everybody. Uh, Time now is 10 a.m. exactly. Is the technical team ready? Okay. No, it's fine. Good morning once more. The technical team was just indicating to me, chairperson, members, and executives, that we should only use these mics at the front. When we respond, a mic will be brought over to you. The problem is that when you use the desk-based microphones, it messes with the camera and the visuals. So that camera keeps on searching for you. So rather, we don't use these. We'll bring the mics over to you. This one is fine. You can use that one. Yeah, good. Let's kick off. Good morning once more. My name is Mukelani Dimba. I'm the executive responsible for education and communication at the Information Regulator. Thank you all for coming through today to be part of this media briefing on the work of the Information Regulator. Um, who we have here today, we have the chairperson of the regulator, Advocate Pensitla Kula, joined by members of the regulator, Advocate Colin Weapon, seated on my left, and Advocate um, Lebohang Strom, seated on the chairperson's left-hand side. We are joined by the CEO of the Information Regulator, Mr. Mosalanyane Mosala, who is sitting next to Advocate Strom. We are also joined by the executive of the Information Regulator. They will introduce themselves as they respond to your various questions. Without further ado, let me hand over to the chairperson for the statement.
Thank you very much, Mr. Dimba, and good morning to everyone, members of the media, my colleagues, the CEO and his team. We welcome you all to JD House, the home of the Information Regulator. We have invited the media here today to update you and the public on the work of the regulator. We'll do this by releasing the outcomes of the matters that we have investigated and the assessments that we have conducted in relation to the Protection of Personal Information Act, or PIA, and the Promotion of Access to Information Act, PAIA. We will also indicate some of the new matters that we are investigating. As a reminder of our processes, regarding our POPIA work, the regulator can investigate a complaint submitted by any person, or it can, on its own initiative, investigate a complaint or assess compliance with the provisions of POPIA by a responsible party. Regarding PAIA matters, the regulator can only investigate a complaint submitted by a requester of information or a third party. Upon receipt of a complaint, the regulator has the option to conduct a full investigation of such a complaint or to resolve it through settlement or conciliation process. As with POPIA, we can conduct an own initiative assessment of PAIA compliance by a public or private body. Where investigations have been necessary, an investigation report is referred to an enforcement committee for a finding and a recommendation of actions to be taken against the information officer or head of the private body in respect of PAIA or the responsible party in relation to POPIA. The Enforcement Committee submits its findings and recommendations to the members of the regulator for consideration. After considering the findings and recommendations of the Enforcement Committee, the members make a determination on the complaint and action that must be taken by an information officer or a head of a private body in relation to PAIA or by a responsible party in respect of POPIA. This determination or decision is issued through an enforcement notice, which must be served on the information officer, head of a private body, or a responsible party. The enforcement notice has the effect of a court order, and failure to comply with it is an offense. Where there is non-compliance with the directions given in the enforcement notice, the regulator can issue an infringement notice, which can carry a penalty of imprisonment or a fine of up to 10 million in the case of POPIA offenses. Now we look at completed assessments and investigations as far as PAIA is concerned. During the 2023-2024 financial year, the PAIA division completed 8 matters, 5 of which have been finalized, 2 are pending before the Enforcement Committee, and 1 ready for determination by members of the regulator. The division conducted own initiative assessments on 108 public and private bodies. One of these matters is the matter of Clive Hardwick on behalf of Hardwick Trading Pty Limited versus RISA Audio Visual Licensing, NPC, referred to as REV. This was regarding the issue of access to records relating to the music royalty revenue received by Gallo for the broadcast of sound recording and music videos produced by Bula Records, which were broadcast prior to October 2014, including but not limited to revenue received from ECHO, SAMPRA, REV, and PPL held by the private body. Following a public hearing that the regulator conducted regarding access to records relating to music royalties, an enforcement notice was issued ordering REV to release all the records requested by the complainant. Although REV had expressed an intention to review the regulator's decision, Gallo, one of REV's members, subsequently disclosed all the records to the complainant. Another development relating to the issue of transparency of music royalties payments happened after the public hearing on the matter between Hardwick and REV. The regulator received a complaint from Thomas Ramatume Mulete, a music producer, who had requested access to records related to the royalties collected from Lesedi FM SABC, so that he could determine if SAMRO had paid him all the royalties due for the period March 2011 to March 2020. The complaint was resolved through mediation facilitated by the regulator, and SAMRO disclosed all the royalties records to Mr. Mulete. As far as assessments are concerned, we conducted under PAIA 108 assessments on public and private bodies, including political parties, universities, national and provincial government departments, and JSE listed companies. South Africa is unique among access to information laws globally because our law applies not only to information held by public bodies, but also to information held by private bodies when that information is required to exercise or protect other rights. Furthermore, our access to information law sets another international gold standard in that it also applies to political parties. The regulator chose to include political parties in this round of assessments to promote transparency by political parties as an essential part of our system of democratic governance. The following are the key findings from those assessments. We assessed 13 political parties represented in parliament and one party not represented in parliament, but with presence in municipal councils nationally. We found that about 54% of political parties represented in parliament are generally non-compliant with PAIA. About 46% of political parties represented in parliament have some level of compliance but need to improve in certain areas. Therefore, none of the political parties represented in parliament are compliant with PAIA. You can see Annexure A, which is attached for summaries of these political parties. 27 JSE listed companies were assessed for PAIA compliance, and all 27 of them were found to be generally compliant with PAIA. However, particular areas of improvements were indicated, such as the designation or delegation of deputy information officers and the production of PAIA manuals that fulfill the requirements of Section 51 of PAIA. 13 universities have compiled PAIA manuals. However, not all universities' manuals were compliant with Section 51 of the Act, and only 40% of the universities made their PAIA manuals available as prescribed. None of the universities fulfilled the requirement for the compilation of notices of automatically available records. Furthermore, we are concerned that only 40% of universities submitted their Section 32 reports to us as required by law. Less than half of the assessed universities had duly designated or delegated deputy information officers. 27 national government departments and 27 provincial departments were assessed. All the national government departments except one have compiled PAIA manuals. One department, the State Security Agency, is exempted by the Minister of Justice and Correctional Services from compiling a PAIA manual. All provincial departments, except the Northern Cape Department of Agriculture, have compiled their PAIA manuals, and only 6 provincial departments' manuals comply with PAIA. Even though the national government departments had compiled PAIA manuals, their manuals are non-compliant with Section 14 of the Act. There are also areas of improvement in relation to other PAIA requirements. Areas of improvement in relation to PAIA requirements include the following: the designation or delegation of deputy information officers. Only 40% of the national government departments and entities had designated or delegated deputy information officers. On the availability of PAIA manuals as prescribed, only 40% had made their manuals available as prescribed. Regarding reporting to the Information Regulator in terms of Section 32 of PAIA, less than half of the national governments have complied with this requirement. We are concerned that some of the departments that failed to submit their Section 32 reports to the regulator include service delivery departments, such as the Department of Health, Higher Education and Training, Home Affairs, and Human Settlements. As far as POPIA is concerned, the regulator received 982 complaints during the 2003-2004 financial year, and 14 responsible parties were assessed. Of these, 682 complaints were resolved and 10 assessments were completed and are ready for determination by the regulator through the issuing of enforcement notices. As we have done previously, we will highlight a few of these to give a snapshot of the enforcement work that the regulator has been doing over the last 12 months. The first one that we're reporting on is TransUnion. In March 2022, TransUnion, a registered credit bureau and a repository, I beg your pardon, of credit information on consumers and businesses, submitted a Section 22 notification that it had suffered a security compromise. The regulator then conducted an assessment which has found, among others, that TransUnion breached the conditions for the lawful processing of personal information by 1, failing to secure the confidentiality of personal information in its possession or under its control. 2, failing to take appropriate technical and organizational measures to ensure access control is implemented as directed by their own policy, and also not having controls to detect this failure. 3, failing to prevent unlawful access to or processing of personal information that enabled unauthorized actors to gain unlawful access through the use of compromised credentials and use of a weak password. 4, failing to implement the safeguards that had been put in place in the form of access management policies and user creation policies. 5, failing to implement the provisions of its own information security policies, which covered the domains recommended to ensure confidentiality, integrity, and availability of its information processing environment as they related to the user creation, which meant there was a user created outside of approved user creation processes, to password complexity, which meant the disregard for the password requirements as set out in their access control policy. Consequently, the regulator has issued an enforcement notice against TransUnion, ordering the company to 1, develop and put in place security measures to ensure the integrity and confidentiality of personal information in its possession or under its control, to prevent loss of, damage to, unauthorized destruction, or unlawful access to personal information. 2, obtain the services of a qualified auditor or audit firm who will perform an audit on all user accounts against the SFTP user creation policy to determine if the configuration of any further user accounts fall outside the prescripts of its policy. 3, conduct a personal information impact assessment to ensure that adequate measures and standards exist to comply with the conditions for the lawful processing of Personal Information. TransUnion has until the 26th of May 2024 to submit proof to the regulator that all the remedial measures in the enforcement notice have been implemented. The second one, South African Police Service Part 1, the Krugersdorp sexual assault matter. In the previous financial year, we issued an enforcement notice against the SAPS for the distribution of personal information of victims of sexual assault in the Krugersdorp area. We ordered the SAPS, among others, to investigate the circumstances that led to this security compromise incident. That investigation had to specify the measures the SAPS had taken to ensure that this incident or any incident of a similar nature does not recur. SAPS has complied with the enforcement notice and the matter is closed. Another matter that we dealt with is Dischem. The pharmaceutical company Dischem suffered a security compromise in May 2022 following a brute force attack that saw the personal information of 3.6 million data subjects being accessed by unauthorized persons from Dischem's e-statement service database. The regulator issued an enforcement notice against Dischem following an investigation into the security compromise. In terms of the enforcement notice, Dischem was ordered, among others, one, to conduct a personal information impact assessment to ensure that adequate measures and standards exist to comply with the conditions for the lawful processing of personal information as required in the POPIA regulations. To implement an adequate incident response plan, implement the payment card industry data security standards by maintaining a vulnerability management program, implementing strong access control measures, and maintaining an information security policy. Third, ensure that it concludes written contracts with all operators who process personal information on its behalf, and that such contracts compel the operators to establish and maintain the same or better security measures as referred to in Section 19 of POPIA. Fourth, develop, implement, and monitor and maintain a compliance framework in terms of Regulation 4 of POPIA, which clearly makes provision for the reporting obligations of Dischem and all its operators in terms of Section 22 of POPIA. The regulator has completed its assessment of Dischem's compliance with the enforcement notice and is satisfied that Dischem is compliant with the recommendations contained in the enforcement notice. As a result, the regulator has closed the Dischem file. Matters that are being investigated at the moment under POPIA. The first one is the Independent Electoral Commission matter, IEC. Early this month, in March 2024, the regulator received 2 security compromise notifications from the IEC following an unauthorized release of candidate lists for the 2024 national and provincial elections. Consequently, the regulator issued an information notice to the IEC seeking further information from them. Following the assessment of the information obtained from the IEC, the regulator has decided to proceed with a full assessment of the security compromise suffered by the IEC. The second matter is the South African Police Services SAP Part 2, Regrettably, we have now had to initiate another investigation into the SAPS for a similar breach of POPIA following the release of personal information via WhatsApp. This follows investigations into the deaths of prominent businessman Jabulani Ben Gumbi and the late Captain Ernest Dambuza. Sensitive crime scene reports and other personal information, including car registration numbers and home addresses of individuals involved in the investigation of the two deaths, were distributed widely via WhatsApp. The regulator is considering measures to be taken against the SAPS for this continued transgression of POPIA requirements. The next one that we're investigating is the Companies and Intellectual Property Commission, CIPC. The regulator has commenced its own initiative investigation of the CIPC following the much publicized security compromise of their systems. Reports received by the regulator indicate that the threat actors that breached the CIPC system are still in the CIPC IT environment, and the CIPC systems remain compromised. Another point of inquiry regarding the CIPC's organizational and technical measures for protecting personal information will be whether the CIPC's business model facilitates the selling and buying of personal information in its possession. As far as PAIA is concerned, we are dealing with the following matters. The first one is a complaint against the State Security Agency, SSA. This case relates to a request for access to SSA's expenditure information from 2015-2016 to 2018-2019 financial years in respect of services rendered to the SSA by the African News Agency, ANA. The investigation has been completed and the matter is before the members for consideration. Then there's the complaint against the Competition Commission. This case relates to a request for investigation reports and measure reports covering 1st January 2021 to 30th July 2022. The complainant submitted that its request for records is motivated by a high number of rejection of measure applications on public interest grounds. Therefore, the disclosure of the records in question will assist in clarifying how the Commission is currently applying the law and public powers when dealing with a major transaction. The next one is the complaints against the South African Revenue Services, SARS. This case concerns a request for access to the records of former President Jacob Zuma, Mr. Zuma, individual tax returns for the tax year 2010 to 2018 held by SARS. In a previous case, the Constitutional Court had remitted the matter back to the SARS Commissioner for reconsideration, and the Commissioner refused access to the records of the former president. The requester has submitted a new complaint to the regulator, and the complaint has been accepted. The last one is a complaint against Sibanye Stillwater Limited. The complaint concerns a request for all annual compliance reports from 2019 to 2023 for the Eastern and Western Platinum Mine Social Labor Plans, SLP, The annual compliance reports that the complainant requires access to relates to the progress on community projects that the mines undertake to implement part of their licensing requirements. I thank you for your attention. This is the end of the press statement. We'll take questions. Thank you.
Thank you very much, Chairperson. Just to remind colleagues from the media to please indicate the media company that you are representing or the publication that you are representing. I also am aware that there are stakeholders in the room. If they also want to ask questions, they are welcome to do so. But please indicate the company you're representing and your name, and we'll take it from there. I'll see by show of hands if we have any questions. We'll start on this side.
Is it? Oh, it is on. Good morning, everyone. Good morning, Chair. I just want to find out in regards to TransUnion. So you guys have issued your excuse. I do apologize. My name is Simnikiwe. I'm a journalist at IT Web. In regards to the enforcement notice against TransUnion, Chair, what is, excuse me, what would be the next steps in terms of, we know that once they don't follow what's the guidelines in the enforcement notice, that then a fine comes along. Is it a case that they will be fined, or is it a matter of us will have to wait and see what TransUnion responds with? And just to also get clarity in terms of, has this notice been issued to them as we speak? So are they aware that they received that? And then I have can I go on? Okay. Chair, also just to go back to, we know that the DOJ was the first entity or department that was issued with the enforcement notice, which led to the fine. Any update in terms of payment of the fine? What are they saying in regards to that? And I just have another one in terms of non-compliance with PAIA. Are you finding that what are the consequences if they don't comply with the enforcement notice in regards to PAIA? That's it for me for now.
Thank you. Next one. Do we have any more? Oh, yes, please go ahead. Your name and your company, please.
Okay. Good morning. My name is Nkosinathi Ndlovu. I'm from Tech Central. Considering that in protection of information legislation is new both in South Africa and worldwide, as the regulator is investigating different bodies both in government and in private business and finding that they're non-compliant, are they catching up quickly enough to the legislation, and do you think that the efforts to align themselves are concerted and making a difference?
Notando Makutelea from SABC News. I understand that the IEC is currently being investigated. Will this be resolved before the elections?
Thank you, Notando. Let's pause it here for now. Take responses from the chairperson, supported by the members and the executives in the room. Chair, over to you.
Thank you very much. The question, the SABC regarding the IEC investigation, Advocate Wikanyo will answer that question. And regarding non-compliance with PAIA enforcement notice, Mr. Namasisi will answer that question. Regarding the DOJ fine updates, let me start with TransUnion. IT Web, yes, the enforcement notice has been served to TransUnion as we speak. And of course, we have given them time, I think it's 60 days. 60 days to comply with the enforcement notice. Only if they don't comply will we then issue an infringement notice. So as you have correctly pointed out, for now, it's a wait and see what we have. The DOJ fine, as you know, the DOJ, they have instituted a review application in court to challenge our decision. So the matter, I'll ask Mr. Jansen to say how far that matter is. And then POPIA, are they catching up with compliance with POPIA? I think from where we're sitting, the private sector seem to be more eager to comply than the public sector. And if you listened to the press statement that I read, Discam complied fully with our enforcement notice. As far as the public sector is concerned, of course, the SAPS complied with our enforcement notice, but immediately thereafter, there was a similar complaint, which then begs the question whether are they really up to complying with the legislation. But we also have to say POPIA is a very complex piece of legislation, and it's new. And the enforcement powers of the regulator only came into effect, as you know, in June 2021. So a lot of private and public bodies are still struggling, not only with implementation, but also with the interpretation of POPIA. That is why, as the regulator, we are available to assist private and public bodies with training on POPIA. But as we do that, we have to ensure that we don't entangle ourselves in a conflict of interest where we give legal advice and thereafter there will then be a complaint lodged with us. So we have to walk a very thin line between providing advice and making sure that in the process we don't compromise ourselves. Advocate Wiganyo and Mr. Masisi and Mr. Jansen.
Thank you very much, Chair. As the Chair has already pointed out, upon receiving the notification from IEC in terms of Section 22, we immediately conducted a preliminary assessment. And our preliminary assessment culminated in us issuing an information notice to the IEC. When the IEC, after the IEC responded to the information notice, we realized that there were certain gaps that needed to be addressed, and there was a follow-up letter that was sent to them. I may add at this stage that we have duly notified the IEC that we have decided to conduct a full assessment in terms of Section 89. Now, we are at a very advanced stage with regard to putting together their report. We are just awaiting the information to come from the IEC. Our target is that in the next 2 weeks, we should have a draft report. That would, of course, depend on when we get the information from the IEC, but we are very much at an advanced stage with regard to that. Maybe to answer your question, that do we envisage to finalize this matter before the elections? As I said, in the next 3 weeks at most, we will be ready with the report. The process then is that the report will serve before the members, and the members will make a determination. And as you would know, in terms of Section 91(3), that report will be the equivalent of an enforcement notice. So we are anticipating that this matter will be finalized before the elections. Thank you, Chair.
Thank you so much, Chair. With regard to the question from IT Web regarding the consequence for non-compliance with PAIA. So PAIA, we've got 2 processes that we follow. In terms of investigation, where a complaint is referred to the enforcement committees and members issue the enforcement notice. The enforcement, non-compliance with the enforcement notice comes with a fine or an imprisonment for a period of 3 years. But the fine and the term of imprisonment is not imposed by the regulator as opposed to POPIA. It's imposed by the court. So it's the court that will then impose the fine and the fine or the imprisonment. With regard to the assessment, where we issue an assessment report, the regulator is developing a process on how we can ensure that we enforce non-compliance with the assessment reports that we issue. And this is mainly because there's a lacuna in our legislation. It does not explicitly explain what happened if the assessment report that has been issued with detailed findings and recommendations are not complied with. So we're in the process of developing the process, but also in the same way, coming up with a proposed amendment to PAIA to ensure that it is explicitly clear as to how do we deal with the failure to comply with the assessment reports that we have issued. Thank you, Chair.
Good morning, Chairperson, and good morning, everyone. Regarding the question from SABC on the DOJ matter, yes, the DOJ did institute a review application, and the regulator was served with that application. We are at an advanced stage, and we are finalizing the process to disclose all the documents upon which the decision was based. Thereafter, of course, there will be a further exchange of affidavits, both from the regulator side and from the DOJ side. And from there on, the matter can proceed. It will eventually be enrolled for hearing. And of course, then the matter can be finalized. Thank you.
Thank you, Chairperson and executives. Let me open another round of questions if there are follow-up questions. I don't. Okay, let me go across the room for now, and then I'll come back to you, Simnigiwe.
Thank you very much. Good morning, everyone. This is not a follow-up question, but just a question in relation to the complaint against the Competition Commission in terms of PAIA. Just wanted to ask whether the memorandum of agreement concluded with the Competition Commission and Information Regulator has an impact, if any, against the investigation against the Competition Commission. Apologies, my name is Dale Adams from Worksman's Attorneys. Thank you.
Thank you. Let's come this side.
Nothando Makutula from SAPC again. I just want to find out if this was the first complaint from the PAIA complaint to SARS regarding Zuma. Sorry, let me just start over. Is this the first complaint against SARS regarding the PAIA? And how far is that investigation going on regarding the Zuma case?
Okay. My follow-up is on TransUnion. Was it, in terms of the data breach, was it the biggest that was reported to the Information Regulator to date? And a follow-up is also just to hear from you, Chair, in terms of what's happening with the direct marketers. So if you have anything to share with us, because I know that you also issued an enforcement notice against a first company in that regard. So if you can just update us as well, please. Thank you.
Okay, let me start with your last question. Then the MOU with Competition Commission, Mr. Nemasisi, you will deal with that together with the SARS complaint. TransUnion, I think it was one of the biggest that we have dealt with in terms of the number of data subjects that were impacted by the security compromise. And then direct marketing, of course, as you know, we issued an enforcement notice against the company that was complained against called REMS Consulting. I don't know, Mr. Advocate Bikanyo will tell us when does the period of compliance ending, so so that we see how this goes. But we are also monitoring whether that enforcement notice has had any impact, you know, as far as the public is concerned. And speaking for myself, and maybe I'm the only one, I see that I no longer receive calls from direct marketers. Even on my SMS and on my email, the traffic has decreased substantially. It could be that it's just me. It would be interesting to hear from you whether you have witnessed any difference since we issued that enforcement notice. We are finalizing the direct marketing guidance note. It's at an advanced stage. And as I indicated before in public, the regulator has taken a stand that direct marketing through a telephone constitutes, in our view, direct marketing through unsolicited electronic communication. We have taken that decision, and we are not going back on that decision. As far as the other questions are concerned, I'll hand over to the colleagues.
Thank you very much, Chair. We have afforded the responsible party 120 days to comply with the enforcement notice. It will end in the middle of June. That 120 days will end in the middle of June. Thank you very much.
Thank you so much. With regard to the question of the matter in which we're investigating a complaint against SAFs, this matter was received now in March. We anticipate that obviously it will finalize by May, but in terms of the question as to whether we had received a complaint from SARS before, yes, we did receive a complaint from SARS before, but not regarding the Zuma matter. But that matter was resolved through mediation process. They're able to disclose the records that were required. So it didn't go through the investigation. So this is the first complaint which is going through the investigation. We've already returned to SARS to give us access to all the records involving the former president. We are also going to send a notification to the former president to inform him about the investigation that has ready to be dispatched, and as well as those other witnesses that we have identified without going into details. But the investigation should be finalized by May, end of May. Thank you. Sorry, there was a question regarding the MOU between the Regulator and Competition Commission. Look, the Information Regulator is supposed to perform its function independently, and we obviously, without fear, favor, and prejudice. So the MOU is just for cooperation in respect of issue of common interest, but it doesn't go into the powers of the regulator. In fact, without disclosing the preliminary findings, there are preliminary findings and recommendations made in the report that has been referred to the Enforcement Committee, which shows that we are actually independent. The MOU did not compromise our independence. Thank you.
Thank you. The Government Pensions Administration Agency posted a notice on their website about a breach a couple of weeks ago. What is the progress on that?
Advocate Bikanyo.
We have issued an enforcement notice, an information notice in relation to the Government Employees Pension Fund. We are just awaiting the response, and this will determine the course that we will take in relation to that particular matter. I will just have to check here as to when. If you just give me a few minutes, I'll just come back to you and just check with the date.
I think this is my last one, I promise. I think this is, just to hear from you, Ched, are you not concerned that, I think you mentioned that 54% of political parties are not compliant, are non-compliant in terms of PAIA. Is that not concerning because these are parties in parliament, if I'm not, yes?
It is concerning because these are lawmakers. But you also have to bear in mind that it is not too long that PAIA was amended to include political parties. So some of the political parties were not even aware that a PAIA applies to them. And I must say that all of them were quite pleased that we conducted the assessment that we did, because it sort of opened their eyes to, how PAIA applies to everyone, including themselves. And we were deliberate in conducting the assessment because we felt that one of the founding values of our constitution is transparency and openness. And that if anything, political parties, especially those represented in parliament, should lead the way in shining the light on the value of openness and transparency. And we're hoping that with the reports that we have submitted to them to point out the gaps in their compliance, they will then make sure that they comply fully. Thank you.
Chair, if I could just clarify the position relating to GEPF, and I just got the two cases mixed up. The Government Employees Pension Fund, Chair, we will be conducting an assessment on the 10th and the 11th. We have duly notified the Government Employee Pension Fund that we will be conducting an assessment on the 10th and the 11th of April. I beg your pardon. We are conducting this assessment in terms of Section 89 of POPIA. Thank you very much. Please ignore the previous statement. We're actually conducting an assessment with regard to GPF.
Well, thank you, everybody. I think this brings us to the end of this press conference. I would like to thank you all for coming through, and those that have joined online. Thank you so much for making the time. There will be tea and refreshments served in the next room. Before you leave, please help yourselves. Thank you.